Be seated. All right, we have the last case. The crowd dissipated. Last case is FAYAZI versus FAYAZI, and civil case, 20 minutes to the side. If counsel are ready, we'll go ahead and begin.
Quick housekeeping question, Your Honor. There's a cross-appeal issue, and typically, in my experience, has been that as the appellee, I address my cross issue at the beginning and then save a minute or two for rebuttal after her rebuttal. Is that acceptable?
Sure, that's fine. Is that all right?
Yes, Your Honor, but for clarification, so I should just do my 20 minutes, 5 minutes for rebuttal, but I'm going to address his cross-appeal issue in my original initial time.
In the rebuttal.
In the rebuttal time. In the rebuttal time.
What if it's intertwined with the whole distribution scheme that I'm arguing?
I really don't think we're going to have a problem.
I'm sorry, Sharon. I should have talked to you about that before. It just occurred to me.
Okay. May it please the
And
court.
I'll give you some extra time if you need it.
Okay, so just for clarification, I can't.
You just go ahead and do your direct appeal, and then after we hear from here, we'll hear from.
Okay. May it please the court. My name is Shannon Macklin Carlisle of the Carlisle Appellate Law Firm, and I represent the former wife, appellant cross-appellee SHAKIBA FAYAZI. Your Honors, this issue, this appeal involves two main issues, one involving custody and the other one a number of financial issues, including the cross-appeal that is, as I said, intertwined with the financial issues that I will be addressing on my initial argument. As to custody, the trial court erred in relying so heavily on Sherry Reich's vocational evaluation that discussed the fact that the former wife had initially discussed potentially moving to California to be closer to her family at the initial onset of the dissolution. In fact, both Ms.
Was the trial judge not entitled to rely on that factor among others?
Yes, he was, Your Honor, but the problem with this situation is that Dr. Reich specifically said that if Ms. FAYAZI was not moving to California, that all five of the factors, which are A, D, C, E, and H, 5 different factors from Section 6113 would have not been in favor of the former husband, but they would have been neutral. But in fact, in the findings of the final...
But we're not deciding whether or not the psychologist erred here. We're deciding whether the trial judge did, right? The trial judge considered all of the factors, right?
Yes, Your Honor, and in those 5 factors, he...
And what's the best you can get here from us, other than to go back to the trial judge and have him reweigh all the factors again, and in which case it looks like he's going to reach the same result, right?
I beg to differ on that issue, Your Honor. There's 5 specific factors out of the, I believe, 8 or 9 that are listed that he specifically relied, and he even said on record, page 206, I'm giving it considerable weight, and I find it of a significant concern. And in this case, there was no evidence that she had even filed a request to relocate to California. There was no evidence that she ever attempted to abscond with the child from California. This was a situation where at the very beginning of a very tumultuous situation and divorce where this woman had never been financially independent and was completely relying on her former husband at the beginning of this situation going, what am I going to do? And so what the trial judge ended up doing was he specifically went through those factors and he relied heavily on, well, she's, said she was going to move to California, so how can I even judge the community based on the fact that she's going to be staying right here in St. Augustine? And so you're absolutely right, Judge Torpy. I'm not asking you, and our request for relief is not reverse and remand and award Ms. FAYAZI primary residential custody. It's specifically to direct the trial judge that the fact that she had specifically...
Wasn't the problem, though, I'm trying to get my head inside the trial judges here, wasn't the problem that that her initial manifestation of an intent to relocate evinced that she was focused not on the best interest of the child, but only focused on the best interest of herself. And doesn't the trial judge have the prerogative to weigh that in as a factor when he's trying to decide which of these parents are the most likely to foster a relationship with the non-custodial parent?
And Your Honor, if that was true, then why do we even have petitions to relocate? Does every mother or father who feels that it would be in the best interest of their child to be with their mother, close to her family support system, to be in a situation, and then after...
Did she feel like it was in the best interest of the child to relocate, or did she feel like it was in the best interest of herself to relocate to California?
I think that she believed it was in the best interest of both to relocate because she felt...
How can she know whether it's in the best interest of the child to relocate before the trial judge has even made a determination of who's going to have primary residential custody and
Right.
what the visitation schedule is going to be and things like that? I mean, how could she possibly know?
I believe in her mind, she honestly believed that it was in the best interest of the child because she was the primary caretaker of the mother. Despite the conflicting evidence on that issue, in her mind, she was doing what she thought, or even contemplating doing what she thought would have been in the best interest of both of them. And so to hold that against her, particularly in light of the fact that the state of Florida permits parents to request to relocate to other...
But generally, though, that's a relocation, and generally, at that point in time, there are lots of issues like availability of work, myriad issues, and in this particular case, it appears that her initial desire to relocate was predicated only on the fact that she wanted to get back to where her family was. It didn't take into consideration any of the issues that might bear on the child. For example, when you take a child to California and a young child, and his father lives in Florida, that may greatly adversely affect the child because of his inability to visit with his other parents. I mean, didn't look like she was really focused on those things, and that may be where the trial judge was coming from here.
But what we can't ignore is the fact that the psychological expert that testified specifically stated every single factor that I just named, A, D, E, H, and J, were in the father's favor. And then, on clarification on page 32 of her videotape deposition, and again at the trial, she specifically stated that if the mother did not move to California, that every single one of those factors would be neutral. And notwithstanding that, the trial judge relied on this California issue, which was a very fleeting beginning part of this extremely tumultuous situation of somebody who is not an independent person, particularly considering the dynamics of this relationship where the husband controlled every single bit of the finances, and again, that's...
Let me ask you about the Bridge the Gap alimony, because I'm unclear about what your position is here.
Yes, Your Honor,
the award is in your client's favor. She's challenging the award. I'm not clear about why your client is challenging the award. If we say that Bridge the Gap alimony is, if we adhere to our prior precedent, then your client gets zero instead of $2,000 a month, right?
No, sir, Your Honor. What I'm arguing, and I'm sorry if I was not clear, is that the Martin case said, I think that we're having a semantic issue between Bridge the Gap alimony and rehabilitative alimony. She presented a rehabilitative plan. And so, in other words, instead of quote-unquote terming it Bridge the Gap alimony, what our contention is, it should have been a larger amount of a combination of lump sum and higher rehabilitative alimony. Because even though they contend that her rehabilitative plan was complete, there were still situations that needed to happen before she was rehabilitated. And the fact of the matter is, she did not have a job. She did not have this $333 a month in imputed income. And so the practical effect of this financial dissolution scheme, in light of the husband's keeping every single bit of his millions, multi-millions of dollars withheld from her throughout the marriage and through his financial acumen that did not include a prenuptial agreement. I mean, if you want to think about it, people have to go into a prenuptial agreement with full disclosure and knowing what they're getting into. In this situation, the former husband was meticulously able to take millions of dollars, keep it from the marriage. She goes into the marriage for 5 years. He has no income. All the marital work and labor and everything is as a result of no income, no marital assets.
I hate to interrupt you because you got some momentum going, but I just have a few questions I want to ask you. How did the 5-year marriage adversely affect her employability?
The 5-year marriage adversely affected her employability because the former husband would not permit her to work. She tried to work. She went to work for 2 weeks and he didn't want her to work. She applied for a job as a secretary and he didn't show up to take care of the children, and so she lost that job. She was not employable.
What did she do before she got married? What kind of work did she do?
I don't know if it's in the record, Your Honor. She was young and married a Muslim in a very unique culture where she wasn't supposed to work, and so for 5 years. But
during the marriage, she gained the ability to work in the medical field.
But during the time of the marriage, she lost 5 years of being able to accumulate one single piece of property or asset in her own name because she had no checking account and no ability to have a portion of the marital home, which again is the cross appeal issue. I mean, if I have not seen a more one-sided final judgment on the disparity of the marital distribution, or the fact that the former husband had he withheld everything from her for 5 years. And in fact, I want to specifically point you to...
But she's employable, and she can earn between $40,000 and $45,000 a year, and it seems that the trial judge accepted the testimony of the vocational expert because he quotes from the vocational expert in his final judgment, right? So,
yes,
we
Your
have
Honor.
to assume that the trial judge concluded that she's employable and she can make between $40,000 and $45,000 a year.
Right. And what's important about that is it goes directly to the next issue, that the fact that he made that ruling as non-modifiable. So here she is, she doesn't have a job because a vocational expert, several months after I'm sure she did the research, the trial was a span of either 2 to 4 months, comes on and says, oh yes, she can get a job. Well, the fact of the matter is this was at the cusp of the beginning of the downturn economy, and even if she got a job, that next day after the trial, who's to say she could keep the job? She'd never even been...
So if it's modifiable, is it modifiable both ways? If she gets a job, can he go in and apply to have the alimony terminated?
It was as if the judge made the ruling of it being...
No, if we rule that you're correct and that the alimony award is modifiable, does it cut both ways? If she gets a job tomorrow, can he go back to the court and ask the court to terminate the alimony?
No, Your Honor, because that specific ruling was based on the fact that she already was imputed $40,000 a year income. He imputed $40,000 in a year income and found that she still needed an additional $2,000 a month. So if she gets a job making $40,000 a year, which even if she doesn't, if she gets it, she may lose it in a week because she's never been employed.
So if you're correct that the alimony is modifiable it may only be modified by the former wife. It may not be modified by the former husband.
Absolutely not, Your Honor. If she gets a job making $80,000 a year, please let him come in and say that she doesn't need the $2,000.
I just wanted to find out if it cuts both ways.
Absolutely, it should cut both ways. And that brings me to another point in this.
Let me ask you another question, though. If the Bridge the Gap alimony was awarded as lump sum alimony like the 2nd District does it, would it be modifiable? If it was, I don't know, what does it add up to, $48,000? If it was $48,000 payable in a lump sum and he paid it, is it modifiable?
I don't know the answer to that, Your Honor, but I think that given the fairness and equity of a marital dissolution court, the way that this final judgment is written is one of the most unfair final judgments I have ever seen in my career.
If our court had approved Bridge the Gap alimony, like the 1st and the 3rd and the 4th have done it, I'm going to leave out the 2nd for a minute, would this award of Bridge the Gap alimony be appropriate?
Yes, Your Honor, at a higher amount. And in fact, interestingly, and I apologize for not citing... What
amount?
Excuse me?
What higher amount? I mean, what amount?
Well, the former wife testified that she would need $5,000 per month in Bridge the Gap or in rehabilitative alimony. The other thing that's interesting is that the former husband stipulated that this $2,000. There was no agreement that that was sufficient.
Is there some logical correlation between the $5,000 a month and some plan, and if so, what is it?
There was a plan, and again, and if you would turn to the proposed final judgment that Mr. Fuller signed, but again, that was also a situation where he was including certain assets that he deemed to be marital and dividable because of the efforts through the marriage and because some different tracing issues that the trial judge found adversely to us on factual issues, and so we did not appeal them. But
what was her plan?
Her plan was that she would...
What was her rehabilitative plan?
Her rehabilitative plan was to become a medical sonographer and make $40,000 to $45,000 a year, and in the equitable distribution scheme, that it also included the appreciated value of his Premier One development stock, that she is now on the hook for $18 million worth of loan that the court didn't give a hold harmless provision of. I mean, there are so many different just sort of tar baby effects of this order where she doesn't get, just like you said, one-sided. This should go both ways. Well, the $18 million investment and promissory note to that Premier One development should go both ways. If she's on the hook for $18 million, then by golly, she should be able to enjoy some of the equities of it. But instead, the judge found it was completely non-marital and then let her be on the hook for $18 million if the husband defaults on that note. So again...
That's not an issue on appeal, whether or not the judge erred in awarding or in declaring that was non-marital, right?
No, Your Honor, it wasn't, because it was based on factual issues that were controverted. And so, but what is on appeal is the fact that he did not hold her harmless to the debt.
Isn't that implicit in the court's ruling? He assigned the liability to the husband, former husband. Isn't that implicit? If he fails to pay the liability, there's an order that ordered him to do that. He can be held in contempt, right?
For the $18 million note? No, she's still on the note.
Wasn't the liability on that note assigned?
How's the court going to get her off the note? How's the court going to order the bank to take her name off the note?
The same way he's not going to order the bank to take it off the note. He's going to order the husband to not hold her responsible for the note.
Isn't that what he said?
No, it isn't. No, Your Honor. No, Your Honor. There are 3 pieces of property in that final judgment that he ordered that was purely non-marital and purely the husband's. The Cali Norte house that that had a mortgage on it, he held the wife harmless off of the bank's mortgage to the Cali Norte house. And then the 2 pieces of investment property, he held the wife harmless
About
on
paragraph
those.
8 of the final judgment, where it says, any liability, et cetera, remains the property, remains with the person to whom the property is titled. Didn't he assign the liability to the husband?
Well, Your Honor, on remand, I hope that you will clarify that, because the appellee has specifically said that she is still liable for the note in his answer brief. So, and said that he, you know.
As far as the bank is concerned, both of them remain liable for the note. I mean,
But the husband should be should hold her.
absolutely, and I think this order permits her to recover back against the husband if she loses anything. Let me ask you this. You've said something about the husband held property back from her. Is it your position that somehow the way he kept things in his non-marital income, either through the trust or any other way, was improper?
It created an extremely unequitable final judgment of dissolution, and completely opposite of all the policy reasons as to why, if you have a prenuptial agreement, you have to have full and fair disclosure.
You would then have us hold that keeping property premarital is a violation of public policy?
Absolutely not, Your Honor. What I'm saying is that we recognize that under the equitable distribution situation, and all those properties were non-marital, and he had the prerogative to do that, that in determining what an equitable situation is for this uneducated, completely financially, I don't want to use the word incompetent, but a much lower acumen than the former husband, that the trial judge should have developed an alimony scheme, whether it's lump sum, rehabilitative, and something to get her on her feet and equivalent, or at least somewhat commensurate to the lifestyle during this marriage. And I'm not saying that this court should just find as a matter of public policy that the husband couldn't do that, but that the trial judge needs, in a court of equity, to be able to use the other tools that he or she does have available to create a situation from going from this divorce to getting Ms. FAYAZI back on track in a way that does not leave her with no ability to put, he's supposed to pay the first month's rent on an apartment and just when now she's paying almost $500 a month in child support to him because he received primary residential custody of the child. And the fact of the matter is she doesn't have that job. And so she has $2,000 a month that now she has to give $500 a month to the husband for child support. She has $1,500 a month and nothing because the former husband bonded off the $68,500 that the court gave. And so I've never seen a final judgment so one-sided and unfair. And I'm not saying that you have to undo all the equitable distribution situations, but this court should have made, and I contend it was an abuse of his discretion, this trial judge, to not create a more realistic approach to get this former wife back on track. Because as many cases say, including yours, you cannot take a spouse and put them from prosperity, living in a $1 million house in a gated community with housekeepers and a pool, and a husband saying, don't worry about money, don't even have a checking account, and then just put her out there with...
You can if it's a short-term marriage, can't you?
Given the fact that this is there are cases that there was an 8-month marriage, and the courts found it to be an abuse of discretion to send somebody from prosperity to destitution, which I contend is what this final judgment does, particularly in light of the former husband's issue on cross appeal.
You've got a little under 3 minutes left.
Total?
Total.
Okay.
I'll give you a few more minutes if.
Thank you.
Or a minute or two if you need it.
Thank
You probably will not.
May it please the Court, Bill Gressley from Jacksonville on behalf of the appellee and cross appellant Ali Fayazi. Excuse my voice, something's going
You
on.
and Judge Harris are in the same boat today. What do you think we ought to do about bridge the gap alimony in this district?
I think it's a valuable tool. I think your decision in Price made a good understanding of why it should be available. I think that the more accurate look at this in view of this in this case, is simply that the parties, when they decided to separate, my client financed and did everything possible to make sure that the appellee received the training she needed to become employable and become self-supporting, and that the agreement, whether or not the other side agreed with it or not, to pay the $2,000 a month in addition to getting her set up in an apartment to live in, was part of that rehabilitative
Was
plan.
there any evidence about what her financial situation was before the marriage?
Glad you asked, because when you raised that, and Ms. Carlisle did not remember, and either did I started...
In other words, I guess this alimony issue, really, at the heart of it is to try and offset the adverse impact of the marriage on the person's financial situation.
I'm glad you've asked it that way, because I have multiple responses. The answer to your question about her premarital status, I had not recalled either, and I pulled out my little summary. The page 18 of the transcript is the trial testimony of Claire Hibbard, who was the vocational expert. She testifies that the appellant had an Associate of Arts degree and was 9 credits away from getting a bachelor's degree in accounting when the parties married. So she had skills. I think that we need to step back from my client's perspective to look at what the trial judge's perspective was, and I have to say this, that the greatest example of perspective I've ever heard is, what did the snail say when he climbed on the turtle's back? Whee! Miss Carlisle has given you a version of her perspective of what these facts show. I'm going to give you another one. The important thing for purposes of this proceeding is, what did the trial court perceive? And I'll go to the issue about the custody evaluation to the extent the court wants to hear, because it is based partly on a mischaracterization of what Dr. Rice testified to, because she didn't say all of these factors will be neutralized. What she said was, and what the trial judge said, was this woman kept talking about moving back to California, and her attorney here can keep saying, well, that was at the beginning when she was upset, but put that in the context of the other evidence. This is a woman who spent from 45 minutes to 4 hours on the phone every day of the week with her family in California. This is a woman who traveled 2 or 3 or 4 times a year and spent 2 or 3 weeks at a time visiting her California family, and who 2 or 3 times a year during the course of the marriage had up to 15 family members staying in her home for 2 and 3 times a week. This is not your typical, I want to relocate just at the beginning of the divorce process. What the judge said in the final judgment, and what I think this court would be well served in keeping in mind, is the judge recognized that the appellant's testimony had changed for purposes of trial. And he viewed it with some skepticism that she was now saying, well, I'm actually going to be here. The alimony issue must be put in context of 2 other factual bases in the record. One is, this woman did not go out and look for a job. She got trained, and then she sat at home. The parties lived in the same house for a year while this divorce process was proceeding. There's no evidence whatsoever that she looked for a job. Her testimony at trial, and this is after she had her certification, she had done her externship, all of which my client paid for. He continued to support her. He took care, did all the child care while she was in school and while she was doing the externship, which was from St. Augustine to Lake City. It's about an hour and a half each way, plus the hours that she's working. She did testify at trial. Well, I need a certification. I've tried to find jobs. Well, she never acknowledged that she had ever applied for a job to Ms. Hibbard, the vocational expert. Secondly, she tried to tell the judge, she told the judge, she tried to get the judge to believe that she needed some kind of, quote, certification in order to be employable. And in fact, the testimony from Ms. Hibbard was, no, you don't have to have a certification. I've talked to the director of your school. He said most graduates do not even get it. And the appellant testified, well, I can only get it once a year. It was given every day of the week in Jacksonville if you wanted it, and it was not a prerequisite to finding employment. Appellant's testimony was, well, I called every place in the Jacksonville area that offered metal sonography, and there weren't any positions available, but she could not tell one place where she'd actually applied for a job.
What do you say about the modification issue on the Bridge the Gap alimony?
Judge, that's legally the stickiest point we have here. And my position is simply that when you look at the other cases, the Betancourt versus Nunez case, the Bloomberg case, and Smith v. Smith out of this court, which talk about it was error to make the alimony non-modifiable, those are all permanent alimony cases. The Bloomberg case would be the distinction. It's a rehabilitative alimony, but the plan had not yet finished. The lady got sick trying to finish law school and needed to take the bar.
Is rehabilitative alimony?
I'm sorry?
In the absence of an agreement to the contrary, would a rehabilitative alimony award, would that be modifiable?
Ordinarily, yes. Under the facts of this case, my position, my perception of where we are with what happened here was that instead of having a formal separation and a rehabilitative plan entered in a final judgment, we had the parties still living together while the wife, the appellant, did her rehabilitation plan. The $35,000 a year for the schooling, plus the extras that went with the schooling, plus the continued support, plus the providing of child care by my client was part of it. The $2,000 a month is the end of it.
But there's only two kinds of alimony under the statute, right? Rehabilitative and permanent, right? So Bridge the Gap's got to be one of the two, right? I mean,
well, and
our court at one time said, well,
you can't.
There's only two kinds, and this isn't one of them.
Well, in Price, you looked at 6108 and said, but trial courts are to be given discretion to do whatever's fair and equitable under the circumstances. The suggestion that's been made here that somehow lump sum should have been given, or there should have been more equitable distribution, is totally ignoring the actual facts of the case.
Let me just stick with modification.
Okay.
Because I got a simple way of analyzing things. I mean, alimony is statutory, right?
Yes, as clarified by our decision.
There's a statute that says, the trial judge can give alimony, and there's also a statute that says alimony is modifiable. How are we going to rewrite the law on that and say that alimony is not modifiable?
You don't have to. If you feel that is the actual state of the law, and I'm not going to stand here and tell you that I disagree with that, what I think is that given the facts of this case, that the educational part of this rehabilitation has already occurred, and there's evidence in the record which the trial judge recognized that the woman was not out looking for work. She wanted to stay at home and then make a claim that she needed $5,000 a month when she testified at trial.
What's the record evidence about her efforts to find a job, say, in the 30 days prior to the trial?
Well, it was her testimony in connection with the testimony of Ms. Hibbard, the vocational expert. The appellant testified that, well, I've looked for jobs everywhere and I can't find one. I need a certification. Ms. Hibbard verified that, number one, she didn't need certification. Appellant says that it only can happen once a year. Ms. Hibbard found that it could happen every day of the week in Jacksonville. She wanted to go do the certification.
But in terms of her employment, she said, I've been looking for a job and I can't find one.
Right, and there was no evidence, and it was brought out by Ms. Hibbard's testimony, and it was brought out on cross-examination that she had not applied for a job. She said, I called every place in the Yellow Pages. She had not applied for a single job. The trial judge, I believe, was entitled to draw an inference from that this lady was more interested in trying to get alimony and wait to see what happened at trial before she actually went and sought employment. But to get back to the modifiable question, Your Honor, if, in fact, the holdings of Bloomberg and your reading of the statute says that it has to be modifiable, then that's the obvious answer, is that you got to say it has to be modifiable. The remainder of the alimony issue is based on a misconception or misperception of the actual record here. Except for the car, that each party had a car and the appellant got hers, he got his, there was no marital estate here. My client, without any legal negativity to be attributed to him, placed all of his premarital assets in a trust. He'd been married before. He was concerned. In the Iranian culture, they had short courtships, short engagements. He lived in Florida. She lived in California. This was a risky proposition just on its face from the beginning. He, with the advice of counsel, placed all of his assets in a trust. They lived off of the income from that trust. There was no marital estate. Ms. Carlisle wants to claim that somehow this is inherently unfair and she went from prosperity to misfortune. The judge did not believe that she had been kept isolated from her family and made to stay at home by this domineering appellant. She had the ability to go to work. She had the ability to go to work at the very latest before the trial when her medical sonography program was finished and she became employable. The real question here is, what is it we're going to distribute? There is nothing left to distribute. What the alimony claim is at bottom, and the Griffin case from this court, which is just something I happen to have read in connection with another brief, just says at bottom the whole idea of alimony is that there has to be some kind of finding that one of the spouses, the receiving spouse, is not self-supporting. Well, we didn't have that here except to the extent the judge could logically and reasonably infer, based on the record evidence, that the appellant was not actively out there looking for work.
Let me ask you about the $68,000.
Yes, sir.
Your cross appeal issue. Ms. Carlisle says in her footnote here, at least in her brief, that if we conclude that the cross appeal is well taken, that we should remand it to reevaluate the equitable distribution scheme. Did you see that argument?
Oh, yeah.
What do you say about that?
Two things. There is no equitable distribution to be had. Ms. Carlisle correctly conceded that the trial judge made a mathematical error. There was no appreciation on the non-marital asset. As a matter of fact, it had gone the other way. There was
It's a methodology error rather than a mathematical error.
Exactly. Right? You're correct, and I appreciate the correction. The reality is there was no appreciation on this non-marital asset to distribute. And again, other than the car, there was no marital estate. What are we doing by remanding the case? To look at a different equitable distribution? There's nothing left to distribute. It's our position that if you had your typical case where you had marital assets and you had some alimony issue and equitable distribution issue, that would be the logical result. But here, what are we doing? We're going to go back to, I think we're entitled, given the state of the law and Ms. Carlisle's recognition, that this should not have been subject of equitable distribution. We're entitled to have an amended judgment.
Well, this asset, if it was a marital asset and the methodology was correct, was done 50-50, but there really isn't any asset to distribute, so you're just left with the cars, right? Is that
exactly?
Right.
And again, we've covered.
It's possible that the trial judge, however, in coming up with this distribution scheme on Bridge Gap, took into account the $68,000, or that perhaps he would have increased the $2,000 had he not had available the $68,000 to give her. It does seem to me to be a rather niggardly award.
It's possible, Judge. I can't sit here and say it's not. I just look at what this whole package was, which you had this alimony issue that really turned on her being rehabilitated and being able to be employed, and she wasn't. And then we had one asset that he incorrectly characterized as a marital asset to be distributed. So it's certainly possible. I don't think, given the totality of this judgment, that this judge is going to decide that, oh, well, she's going to get something on the other end because she still doesn't want to work. But can I speculate as to that? No, I cannot. I don't think it's an error as a matter of law.
$68,000 is lump sum Bridge the Gap, right?
Your Honor, I should have looked at the lump sum issues harder before I came here today. My recollection was there had to be some outstanding justification, some way to make an equitable distribution no, I said that wrong. That lump sum only exists if you had some overriding equitable issue or it was a part of equitable distribution. But I can't honestly say that. I would be remiss if I didn't touch briefly on this child custody issue, because that was the most important issue at trial from the client's perspective. A lot of time and effort went into this. The 3 statutory factors where this relocation to California was mentioned was subsection A, and 26 through 29 of my answer brief covers these very specifically. The parent who is more likely to allow the child frequent and continuing contact with a non-residential parent. They mention, Dr. Reich mentions, and the final judgment mentions that the former wife had talked about moving to California. Again, I started my argument here by pointing out that the trial judge looked at the appellant's credibility on this issue somewhat askew, given that she had continually said she was moving back to be with her family and then changed it for the trial. But the bottom line is, substantively, this woman demonstrated many habits that were not in this child's best interest, and they were well documented, about sleeping in the bed, not 95 days of missed school the year before. But the important one for purposes of this factor, and what I submit drove this decision from both Dr. Reich and the trial judge's point of view, was that the appellant's coping mechanism for conflict was to shut up, and I don't mean that in the way it sounded, but to turn herself off and to not communicate. That factor permeates a number of these findings, that she would not communicate with the husband, that they lived together for a year until the divorce was final. She had not talked to him for, I think it was 8 or 9 months prior to this trial. How can you parent if you won't talk? My client testified that the only way he could communicate with her, even though they were living in the same house, was through email. The next factor was E, the permanence as a family unit of the existing or proposed custodial home. Again, it's a reference that she's talking about moving, but the reality is that the husband is staying in the home that the child has lived in. He's going to the neighborhood school with kids that he went to early K for. Substantively, this relocation issue had no role in this. That was just a recognition that the former wife said, that's where I'm leaving. Ms. Carlisle misstated that factor H talked about relocation. It does not.
Remind me, how old is the child? How old was
it was 4 years old at the time of trial. I believe
How
it
old?
was 4.
4.
And J, the willingness and ability of each parent to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent. It mentions the relocation, but again, it is really based upon what is it that the former wife did in dealing with the husband, which was didn't talk to him. The child was obviously unhappy when the parties were in the same room. Dr. Reich observed that, noted it in her report. She did not say in her deposition testimony, which was what was used at trial for her testimony, that all of these factors would be neutral if the relocation issue was there. She said that the factors where she mentioned relocation, it would be neutral. But the bottom line is, she said the best outcome for this child is for both parents to be involved in the parenting, for the child to live with the father because of his I will call it more normal pattern of making sure the child had a standard time to get up in the morning, a routine, go to school, come home and play, eat decent foods, not cheese puffs for breakfast like the wife liked to feed him sometime, a normal bedtime, and he had a structure. The testimony was the former wife liked to play computer games and talk on the telephone with her family for hours at a time when she was supposed to be watching the child. It didn't make her a, quote, bad parent. It didn't mean she shouldn't be involved, but Dr. Reich specifically said this child should live with the dad on the day-to-day basis. The mom should be involved. The best solution is if she does not move to California, so she can actually be here with hands-on. I've got, according to the clock, a minute and something left. I'll just take a second at the end to address the cross-appeal issue, if I could.
Thank you, Your Honor. I really definitely would like to clarify one thing about the fact that Appley cross-appellant said that Ms. Reich did not say that those factors would be neutral. In Exhibit 32 that was entered into evidence on page 22, the question is, if Ms. FAYAZI had no plans to relocate to California, I believe your testimony on direct with those factors where they played a role would be neutralized. Would they not? Answer, yes. That's on page 22. So again, I just want to clarify that. Number two, I wanted to address Judge Torpy's position where he said, well, this is a short-term marriage and not a long-term marriage, and so you don't need to establish a lifestyle commensurate with the lifestyle of the marriage. And I would urge you all to read the Bloomberg case, which is completely relevant in this case. And that was a situation where the wife was being rehabilitated to go to law school, and she had some different unforeseen circumstances that occurred during the 3-year rehabilitation period. So this case stands for two important propositions that are relevant to this case. Number one, the court held that it was wrong to state that the court wouldn't hear it anymore after the 3 years was up, and they said that it was wrong to not allow it to be modifiable based on a change of circumstances. The court specifically said that there was no track record that she had in being a lawyer or going to completing her law degree and being a lawyer. And in this situation, the former wife does not have a track record in employment in medical sonography, notwithstanding the fact that her income was imputed to that effect. So just as if she could go get a job in medical sonography 2 weeks after the trial, she could very easily get fired from her job in medical sonography because she's not accustomed to being in the workplace. And so it was an abuse of discretion for the court to not enable that to be modified based on circumstances that occur in the future. Number three, in the Bloomberg case, and again, this addresses Judge Torpy's specific position or question with regard to, well, isn't that only with permanent and not with rehabilitative alimony? And at the very first paragraph of the case, he says that Marilyn, who was the former wife, whose income as a social worker supported the couple while Edward attended law school and enrolled. Okay, I'm sorry, that's not it. Okay, here it is. If the party seeking an extension or modification of alimony cannot go it alone, or if he or she is unable to, quote, be in a position reasonably to continue to maintain the lifestyle to which the parties had been accustomed to during the marriage, the petition for modification should be granted. So again, that case addresses that. I have one other point that Judge Harris hit the nail on the head when he said that $68,500 was considered by the trial court in making this scheme. Judge Sharp's concurring opinion in Odell, the 5th DCA case, 1991, quote, each piece of a dissolution judgment is an interrelated part of the whole. And that's on page 1092. That's extremely important that this court knew that. And then finally, I want to point to Appellee Cross Appellant's reply brief, who he stated a very telling quote, the former wife's reference to the fact that Mr. FAYAZI leaves this marriage a millionaire and she leaves with nothing are correct. And I contend that that is an abuse of discretion of this court, the trial court, to have placed the parties in the overall financial scheme that they did, particularly in the light of the fact that the 68.5 was not marital because of the former husband's extreme financial acumen in keeping all of his assets non-marital and in making no marital assets during the five years of this marriage. So I urge you all to reverse and remand with arguments consistent with the initial brief. And the case, in my opinion, needs to be remanded anyway. And so why not give the trial judge the opportunity to reevaluate those custody factors, not considering the California issue, considering what is going on now, where the wife and husband are continuing to live in St. Augustine. If there are no further questions, then
all right,
thank you.
I'm going to stop it here. I'm going to give you a minute for that cross-appeal issue, and then you can speak to that 68.5 again if you want.
What is the cross-appeal issue, since she agrees?
And I thought that I was the appellant on the cross-appeal issue, and that was her response. But it's very
Yeah,
simple.
Well, I mean, I thought y'all had already finished until you made that remark. And I just want to make sure that everybody has everything heard on that last issue that they that they want to.
Your Honor, on the $68,000 68.5 cross appeal, I don't need to come back up to let you all know that I agree wholeheartedly with Judge Harris's at least comment that if that needs to be reversed, that the entire financial, not necessarily the equitable distribution scheme, but the financial scheme of what is going on here needs to be revisited so this former wife can get on her feet.
Okay, gotcha. You got anything further to say?
Just simply, Your Honor.
Come up to the, if you do, come up.
And I don't disagree that it needs to be reversed to eliminate the 68.5 because it's a non-marital asset. The question is, does this judge, given that the testimony and the evidence that he found persuasive was that she's not looking for work, what do we need to look at again? Obviously, if this was your standard case where you had multiple components to consider, that would be certainly the correct result.
Okay.
Thank you, Your Honor.
Thank you.
All right, that's the last case for the day, so we'll be in recess until Thursday.